Hey, everybody. This is Kathy. Thank you so much for being here this evening, afternoon, morning, whatever time it might be, whatever day it might be, wherever you are. We decided to come on live to talk about the cases that are related to Idaho versus Kohberger because there has been so much that has happened this past week with these multiple cases, starting with Scofield versus Guillard. Scofield versus Guillard is the Idaho for defamation case. It's the oldest of all the cases that are related to Kohberger. That case was filed in federal court back on December 21st, 2022, and the plaintiff sued for defamation. The plaintiff, University of Idaho professor, teaching at the Moscow campus. She was a history professor, still is. And she alleged that she was defamed by the defendant, who is described as an online content creator. She was very big, from what I understand, on TikTok. I'm not very familiar with her TikToks that she published. But apparently, according to the complaint, she was very, very present in the first weeks after the investigation. And by end of November, beginning of December, she had alleged that Professor Scofield was involved in the catastrophic events that happened at 1122 King Road. She came out and named her by name. And her attorney, Wendy Olson, who coincidentally, we're going to be talking about shortly, also represented the media coalition several times in Idaho versus Kohberger, trying to get the gag order at first and then trying to get the case opened up. Scofield's attorney wrote to Ms. Guillard twice and said, "You're defaming my client. Demand that you take down your content." And she wrote one time and there was no response. And she wrote a second time and there was no response. So I think that had a big impression on the judge and jury, that she didn't rush to court first. She went to the defense and she said, "I believe you're defaming me. I want this content taken down." And she refused to do it. She admitted in the course of the case that she had received the cease and desist letters, but elected not to do anything. The case proceeded for 3.5 years. It went to trial, and when it did go to trial, the jury returned one of the largest defamation verdicts in Idaho history, $10 million against the defendant and in favor of Scofield. And people have asked, why was this judgment so large? Well, we have been following this case for some time. And if there's one reason why the judgment was so large, it's because Scofield moved to amend her complaint that she filed on December 21st, 2022, to add punitive damages claims. And the judge allowed it. And so once the punitives were on the table, I've always said, I said, look, other cases where plaintiffs have been, I don't know if she's going to be victorious or not. The jury could have returned damages of zero, but punitive damages are nothing to take lightly. Because if you look at punitive damages cases, I remember saying this several times, sometimes the jury will return a verdict higher in the punitive damages because they're intended to be punishment damages for shocking behavior. They can be multiple times over with the compensatory, which means to reimburse the plaintiff if the plaintiff is victorious. And that's exactly what happened. Of that $10 million verdict, $7.5 million were punitive damages. Jury returned that verdict on the 27th of February. Judge Patricchio entered the final judgment, agreeing with the jury verdict on March 5th. And we've just had Attorney Olson come in, and in the complaint, plaintiff asked for reimbursement of her attorney's fees and costs. It's not cheap to file a lawsuit anywhere, especially in federal court. There's court costs. You file a complaint right away, several $100s. If you have to order a transcript from a deposition, that costs. Then if there's travel expenses for expert witnesses, which there were 2, that costs. So now what the plaintiff did is file on Thursday motion for reimbursement of attorney's fees and costs, and that's another 6 figures. So plaintiff filed that. Defendant Scofield will, of course, have the opportunity to come back and file a response in opposition. She has an opportunity to be heard, and then ultimately Judge Patricchio is going to decide whether or not these attorney's fees, 6 figures, should go into what Professor Scofield is owed, and it will bring it to $10,100,000 and something thousand in attorney's fees and cost. The other thing that we're looking at is before this matter went to trial, the defendant tried to get an interlocutory appeal. You have to ask the court for permission to do that. That is an appeal before the case ends. She was arguing that the federal court lacked subject matter jurisdiction, lacked the ability, lacked the authority to preside over the case, saying that it should have been filed in state court, not federal court. And Judge Patricchio denied both of those. That was just right before trial. So there was also an interview going around, or something that she published herself, saying that she was going to appeal. So we're waiting for this appeal. She only has 30 days to do it, according to the federal rules of civil procedure. The last time we checked was yesterday, the 30th of March. She still hasn't filed a notice of appeal as of yet. So we'll keep you posted regarding that. That is the first case to come out of Idaho versus Kohberger. The second case, which really nothing had been heard about in multiple months, is Laramie et al. Versus City of Moscow. And this came front and center with this EWU case that was filed. This public records lawsuit that EWU filed against the City of Moscow and the Moscow Police Department. Now, what's happened is that Laramie, last year, it was Karen Laramie at first. She filed a petition for an injunction in Latah County seeking to enjoin the City of Moscow and the Moscow Police Department from releasing principally body cam images and images from inside the bedrooms, but also from throughout the home at 1122 King Road that the Moscow Police Department took when they conducted their investigation. They were the first on scene, right? You've seen the body cam. You've seen Officer Nunez arrive minutes after 12, go through the house, followed by Officer Warner, Sergeant Gundersman, Corporal Snyder, who took the photographs, the earliest known photographs at the scene. He took them on his iPhone. We can see him doing that on other iPhone, on body cam footage. And also Officer Smith. Those were the first 5. And they had their body cams on for the most part during the day. And what Laramie, and then she was joined by members of Ethan's family, Ethan's mother, Ethan's father, and Ethan's sister, joined as other plaintiffs or petitioners in that case. Not Hunter. Hunter is not a part of Laramie at all. He's not a part of the EWU case also. But anyway, you may have remembered last year, we certainly covered it. We watched the proceeding before Judge Marshall. She is the presiding judge in both EWU and Laramie et al., which EWU refers to. And she received. The plaintiffs were successful. They got that injunction preventing the City of Moscow, the Moscow Police Department, from releasing certain documents as part of public records requests that people have wanted. And so that was back in early October of last year, and really nothing. It came up once in a while, but not really that much until EWU Media. Okay, so we have first case related to Kohberger was Scofield versus Guillard, the Idaho 4 case. Then Laramie et al. Last year. That was a case pursuing an injunction and receiving an injunction. And then before EWU, we have Goncalves et al. Versus Washington State University, which we're going to put on the back burner for now because I'm going to talk to you about EWU a little bit. I think that that's what a lot of people have questions about. A lot of people are interested in. EWU Media filed actually with the petition for declaratory relief asks for it is asking for remedies about documents that were withheld, they say wrongfully, by the city of Moscow. And what the petition, and we're going through it. We like to go through documents very thoroughly. When we went through Laramie last year and that injunction was issued, we went through it page by page. If you want to look it up, it's in our library. Just go through the search engine. If you plug in Laramie, it'll pull up all of the recordings and the presentations regarding Laramie. But we're doing the same thing with this complaint. And what we're learning is that EWU filed what they said was an informal request for documents from the Kohberger case, from the Moscow Police Department. And what she says is the attorney for the city wrote her back and said, you're going to have to go through the portal and do it formally. The informal request was a very interesting time that it was filed, June 30th, 2025. That's the date that there were some rumblings about a potential plea deal between Mr. Kohberger and the state of Idaho. Before then, everything was full speed ahead, moving toward trial. Trial was supposed to happen in August. Jury selection was supposed to happen in July. So it's June 30th when EWU says they filed an informal request for documents from the Kohberger investigation. Hey, Written Dreams, good to see you here. We have chat going on if anyone wants to join us. Please do. Please also, if you could hit the like button and subscribe to the channel, because there's a lot of things happening right now. We're doing a lot of coverage on these cases, and this way you can be apprised as to what's going on with them, because we really do focus on the documents to let you know what is going on in court the best that we can. So what the petition that EWU filed says is that there was an informal request for documents from the Kohberger files from Moscow Police Department. The attorney for the city of Moscow wrote back and said you have to put it in a formal request via the portal. And it was several days later in July when EWU did just that. And apparently, according to the complaint, and we're going to go over this in the next episode. We have the first episodes out where we went through pages 1 and 2. We're going to get into 3 and 4 in this next episode, which will go over in detail what happened leading up to the lawsuit. So what EWU is alleging is that they then went through the portal and they asked for specific documents. And what the city attorney did is wrote back and said, you need to be more specific. We've heard this before, haven't we? With other people who filed public records requests with the city saying, hey, you weren't specific enough. We need you to be more specific. Well, this is exactly what EWU is saying happened to them. Hey, Glenn, glad to see you here from across the pond. Hey, Daniel, thank you for being here. Legendary CEO, one of our members of our channel, which we are so greatly appreciative for. Thank you, everyone, for being in chat and for being here today, taking time out of your very busy schedules. I really appreciate your time and your attention. So there was some back and forth, apparently. And ultimately what happened is some documents were released, but there were some heavily redacted documents. And there is mention of this injunction that happened in October. And although it doesn't say what it is the Laramie et al. Injunction that Judge Megan E. Marshall entered last year. So then what happens? All right, so the plaintiff or the petitioner feels that there were wrongful withholding of documents. They're citing to Pennsylvania law. No, you got to look at the Idaho statute, is what the plaintiff is saying here, EWU. You don't go by a Pennsylvania statute and then say you can't disclose documents under the Idaho Public Records Act. You're operating under the Idaho Public Records Act. And then there was also the FOIA, the Federal Public Records Act, with no citation next to it. You just can't, do something unsupported and say, oh, well, federal law said. What federal law? What portion of FOIA are you saying? And then they're also saying what I've been saying forever, which is that Idaho State Police, the feds, Latah County, none of these agencies wouldn't have been involved if the Moscow Police Department didn't bring them in. It's sort of like, if you work for a company that has a subcontractor. They have subcontracting agencies maybe to come in and do their marketing for them. They wouldn't be there if you didn't hire them. I've been saying for a long time, it seems to be a puzzling reason that they're giving, hey, we can't give you something we don't have. Well, these other agencies wouldn't be here, Moscow Police Department, if you didn't invite them in. And that's maybe something you should have thought about before you invited other agencies to come in. That's an issue in this case. They're saying also that City of Moscow has wrongfully withheld. They want their attorney's fees and costs reimbursed. They want the judge to release these documents. And they're asking for a few other things. That's the remedies. And we'll be going over everything line by line, like we did with the injunction last year. Now, what makes this even closer to the Kohberger case is the interveners. Earlier this month, March, the plaintiffs from Laramie et al. Versus City of Moscow, who got this injunction last year from Judge Marshall, intervened in the case. They did exactly what Wendy Olson did when she represented the media coalition. She filed papers to intervene. She intervened on behalf of the media in 2023, Latah County, trying to get the gag order set aside. Unsuccessful. Went to the Idaho Supreme Court. Unsuccessful in getting the gag order set aside. She reemerged last year, Latah County. She was at a hearing, you might remember. It was a virtual hearing before Judge Stephen J. Hippler. And she wanted to have Judge Hippler unseal one of the many hearings that have been sealed in this case. The motions to suppress hearing that were in January of last year. Remember when Detective Brett Payne took the stand? And it was also intertwined into the motion for a Franks hearing. Everything got denied. But the media wanted those proceedings to be open to the public. Judge Hippler denied that. And he said something that was really kind of ironic to me. He said, I've told both of these guys, pointing to the plaintiff and pointing to the state and pointing to the defense, they have to stop filing motions to seal documents. It's got to be the exception, not the rule. And they got to be very specific in what they're asking for. Otherwise, it's going to be denied. What does he turn around and do? He approves every motion to seal through the end of the case, and he's still continuing to seal documents from the public, as much as this last document that he sealed. The second order, apparently, the state came back not once but twice after he made his decision back in December for the January, February, and March documents that are under seal. There's 89 of them that he ordered to be unsealed. He actually ordered 90 to be unsealed. He's released one in February, the one dealing with the text messages. Where are the other 89, Judge Hippler? It's a very puzzling thing to me. But then again, when I was doing the podcast verbatim, as the case was going along, another motion to seal, evidence to the public, here's another stipulation, and here's another order sealing. I've never seen a case sealed like this case was. And it's not just it's the hearings that were behind closed doors. It's the gag order. And everyone keeps, well, he pled guilty. Yes, he did. We all saw it, stood up in open court, and he pled guilty on July 2nd. There is no question about that. But him pleading guilty and the oversealing of this case that's still sealed 8 months later, when you're saying there was no one else involved but him, it's two different stories. And no, they come, well, the defense, they looked at if there was anything there, the defense is not there representing the public. The defense is not there advancing the cause of the First Amendment. The defense is there to defend Mr. Kohberger. What's going on with the unsealing of this case, we're going to talk about in just a little bit. I wanted to welcome a few more people. I'm glad to see a lot more people have joined. Christina, hey, glad to see you here. SJS, philosopher, great seeing you here as well. Glenn, perfectly broken, another one of our members. I really appreciate our members, all of the support. Thank you so much. Thanks for being here. And so let's get back to this new lawsuit in Latah County. So I did a couple things this past week. Look for our content. We're going to be putting something out tomorrow on pages 3 and 4, going through 3 and 4 of this petition that has been filed regarding, this is a public records request lawsuit. Wrongful withholding of public records is what the plaintiff is alleging. Now, the defense needs to be heard from the city of Moscow and Moscow Police Department. They haven't filed a response yet. And also the interveners are going to be heard from. Judge Megan E. Marshall put out a schedule on the 13th for when things need to be due, the responses to the petition for this lawsuit that this organization filed. But then May 18th, 10:30 a.m., there is a Zoom hearing where she's going to do exactly what she did last summer. I know several content creators, mainstream media also televised it live because it was live streamed, and it was the hearing on the Laramie et al. Matter that was live streamed to the public, and you got to hear the questions that were asked and the responses, and you got to hear Judge Marshall's commentary, and it gave, I think, a little clues into how she was going to potentially rule. She didn't rule that day. She reserved ruling, and then beginning of October came the court order. Well, we're going to see the same thing, 10:30, hopefully. I reached out to my contact that I had been dealing with, who helps to organize communications with members of the media, content creators, and so forth. And I sent an email last week asking if this proceeding was going to be live. And what he said is, hey, there's not been the type of interest that we had. Maybe if more people reach out, maybe if members of the media, when they realize this is a Kohberger related matter, I don't think mainstream realizes that. Idaho Statesman hasn't reported on it. They've reported on everything. They've reported on everything. Scofield versus Guillard, the WSU lawsuit. They've reported on Laramie last year. They haven't. I don't think they've said a word about this case yet. If the Idaho courts start to see there's a lot of interest, then the Idaho courts may start putting out press releases and start, and possibly consider live streaming this. And I placed a phone call yesterday and follow up to someone else. And, they're looking into it and going to let me know. That was late yesterday that I placed that phone call. So I would love to see this live streamed. Wouldn't you like to see this hearing before Judge Marshall? To see, this is the first one. This is the first time that all of the people who have filed public records requests and have been disappointed with what they got. They feel they've been overcharged. They felt that, things were slow. They felt that things were not produced that should have been produced or were heavily redacted. That's what this lawsuit's about. And another thing, I'm curious. if anyone else who filed a public records request was disappointed in what the response was, that they might intervene in this lawsuit. I'm going to, keep my eyes open for that. There may be interveners who filed public records requests in the Kohberger case. Sometimes that happens in these types of cases. So a judge had video right on late. I thought Glenn saying, Kathy, clearly the bomb. Oh, thank you, Glenn. I appreciate it. No pain, no gain. That is true. That is true. Okay. So we got that happening, but mark on your calendars the 18th of May, because that's when the hearing right now, and it could get adjourned. I mean, she adjourned it before. If there's any other people that intervene, it might get adjourned, because then they're going to need more time for people to be heard from. So that is the one. Okay, so we have, what do we have? Scofield versus Guillard. We have this public records request lawsuit. Oh, no. We had Laramie et al. For second, and then this public records lawsuit. What can be said about Goncalves versus WSU? It seemed for a long time nothing was happening. People were asking, what's going on with the case? When I would try to give an update, it was like, okay, we're waiting for a ruling, or we're waiting for a response, or, this is, we're in the waiting mode right now. And boom, everything just, bombs dropped on this past Thursday, because what we learned on Thursday is that the parties, Washington State University and the attorneys for the plaintiffs, were apparently negotiating. They were doing, let's make a deal behind the scenes. If you drop your motion, we'll drop our motion. The first motion that was filed after this case was removed to federal court, as it was back in January, was January 30th, the defense's motion, that's WSU's motion. They wanted this case moved to the Eastern District of Idaho, closer to where they said everything happened. They argued. They made some good arguments. They said, look at the complaint. The complaint says, hey, Mr. Kohberger worked in the Pullman campus. He was a teaching assistant there. He was studying for his PhD first semester there in Pullman, not here in Seattle, in Pullman. He was given an apartment on campus to live on, off campus apartment, Stepto Apartments in Pullman. Moscow's, of course, right across the border, just a few miles. These students that supposedly made these 13 complaints, they all went to school there. All the records, all the documents, all the physical buildings, the people that are on, a lot of them that are on the plaintiff's witness list, employees of WSU, for example, they work and they live near the Pullman campus. So there was a lot of points that were made. Well, the plaintiffs came back and they did not want this transfer, not one bit. They opposed it. They wanted the case to stay Seattle Division, Western District. And then the reply came when the WSU came back one more time on the 27th of February and said, no, plaintiffs got it wrong. This case should move Judge Kimberly Everson over to the Eastern District courthouse closer to Pullman. And then on the 27th, another bomb dropped. Plaintiffs filed a motion to strike the defendant's answer in affirmative. That would have been a disaster for WSU. They would have been successful in dropping and getting Judge Everson, or whatever, if there was a transfer that happened and then the judge in the new court granted that motion, that would have been a disaster for Washington State. They would have been exposed. It would have been like, okay, next step, default. You have no defenses. It's a little bit harder than that, but I mean, taking it to its ultimate, so that's why I feel of the two, I think that Washington State University definitely got the better of the bargain there, because they were looking at having their motion, their answer and affirmative defenses stricken. So what they did in this agreement that we went over the other day, it's the last document on the docket, is the plaintiffs have agreed that if Washington State University wants to amend their complaint, like they're going to bring in possibly a counter defendant, they made some whispers of that in that first affirmative defense. They said, hey, WSU, if you suffered any damages, you need to look at other people or other entities, not us. So WSU, possibly, that's what counter plaintiffs do. It's called third party practice. They look at other people that they feel, hey, I got sued because of what you did. So now I'm suing you and you're in here. You're a part of this. You know, no facts yet that that's going to happen, but they've whispered about that if you read that first affirmative defense and their answered affirmative defenses. So also a big bonus for the public for transparency, because remember what the Western District is part of the pilot program. Cameras in the courtroom. One of the few federal courts usually do not allow photography, no photographs. You got to leave a lot of times. You can't even go into the courthouse with an iPhone. You know, I mean, no technology at all. People will literally, if there's a potted plant outside, attorneys will leave their cell phones there because they're trying to rush to get to a hearing and they don't have time to go back to their cars. And they got to get through that metal detector, and they can if they've got that phone on them. Well, fortunately for those who believe in transparency, the Western District is part of the pilot program. One of a few courts across the country that are. There's a form that needs to be filled out. There's a process. It's not automatic. Every hearing trial is going to be live streamed. Nope. Either the parties can apply for something to be live streamed, or a member of the public can do it. Same with, a content creator who's interested, or member of mainstream media. You fill out a form and it needs to be approved. But there's a possibility here. Okay, Glenn's saying, let's sue everyone. Oh, Amy, thank you. Please, everyone, hit the like button. Hit the like, hit the subscribe. I'd really, 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 really appreciate it. SMC Idaho Vandals, very happy to see you here. I know that you are very much into the documents, which if you don't like documents, this probably isn't the channel for you, because we really heavily focus on the documents. Then we'll throw in, some theories or some commentary, but everything is going to be based, and it's going to be, citing to something in the official record. All right, so now what are we waiting for? Judge Evanson had said when that motion for transfer of venue was pending, she had said she's not putting out a scheduling order until that motion to transfer venue was entertained, because, hey, if she would have agreed with WSU and transferred the case, all that time, and there's a lot of time, you're going to see this very long court order coming out very soon. All the time put into that Rule 16 case management order would have been a waste of time, because the case would have been closed in the Western District. Now that that's not going to happen, she's got to put out, it's per the federal rules of civil procedure, she's got to put out the scheduling order. And you might see a trial date on that scheduling order. And from what the plaintiffs have said in opposing the transfer of venue, they said, Western District, it seems things move a little bit more at a brisker pace here, than the Eastern District, tend to lollygag around a little bit. They use more artful words than that, trust me. But it was like, data filing to trial date could be a year. All right. If that's the case, there's a possibility that this trial could be set for January. It may be set for a little bit later than that, especially if somebody gets pulled in as a third party defendant. But don't be surprised if when this comes out, you don't see a trial date January of 2027. I guess that would be February of 2027. Rule 16, she's going to have all of the other things that happen working backwards from trial, when discovery cutoff has to be, when any motions for summary judgment have to be filed, when court ordered, a federal court absolutely requires mediation. Nobody gets to say, oh, no, I'm not going to mediate this. I want my day in court. They don't allow that in federal court. You got to go to mediation. Sometimes they require parties to go twice. Sometimes there's an early mediation relatively early in the case. And then as it gets closer to trial, after discovery is in, evidence is in, there's more clarity regarding what the evidence is, what the exposure is to both sides. Then they might go to mediation a second time. Not to say that's going to happen here, but you can take it to the bank. They're going to go to mediation at least once because they're going to be required to. And then other deadlines to amend the pleadings. The plaintiff, if the plaintiff feels, hey, there's another claim that we want to bring, over and above the Title IX claim that we have, that's count one, and all the negligence counts and all of the wrongful unaliving counts that's in there, they may want to bring another claim. There's a deadline to be able to amend, and they're going to you have to ask the court for permission to do that. It's called leave of court. You got to seek leave of court. Or the defense, if they feel they want to bring in a counterclaim against the plaintiff. Sometimes it takes discovery before you have facts that you can do something like that. So that's the type of things that we're going to be seeing here. In this scheduling order, we may be seeing Judge Everson might be coming out this week with this scheduling order. Who knows? One of the things that is going to be in the scheduling order, will the parties agree to a magistrate judge, not the district court judge? Judge Everson is a district court judge. She's a federal district court judge. Every party is asked, will you consent to jurisdiction by the magistrate judge? It's exactly what Scofield and Guillard did. They agreed. Judge Patricio is not a district court judge. He is a magistrate judge in the Idaho 4 defamation case. So that's also one of the things you're going to see in this scheduling order. It might come out, like I say, possibly this week. I'd be very surprised if it doesn't come out within the next 2 weeks. And you might see, as I said, a trial date in WSU versus in the Goncalves et al. Versus WSU case. Any questions, comments that people are making regarding these cases? Hey, Twiz, good to see you. Hey, Blue Devil, so happy that you're here. Amy again. Yes, if everyone could please hit the like button, hit the subscribe button if you aren't already subscribed, because things are going to start happening very, very, very quickly. All right, I got to get on my soapbox here for the last one. Got to return to the origin, the Idaho versus Kohberger case. Now, if you listen to my podcast, which predates this YouTube channel by a long shot, where we on Spotify, and it populates out to Amazon, iHeartRadio. I'm trying to think who else, Apple, iTunes. All of these other places out in wherever, Russia and South Africa and Japan. That I don't even know. I mean, as a matter of fact, one of my first followers on Spotify was from Japan, and felt that Mr. Kohberger was getting a raw deal and called him Sensei Kohberger. I had to look that up. That means teacher, because he was teaching at WSU. Anyway, if you listen, and there's about 900 episodes, we literally went down that docket from day one. First, I should say 4 filings. 4 filings, December 29, 2022, when the case was opened. Does anyone know what those 4 filings are? Amy's always saying that we ask questions around here because we want to learn stuff. We want to learn stuff as we're going along. What were the first 4 documents that initiated this case on December 29th? Now, the case, December 29, 2022, the case ran. It was active for over 2.5 years. The criminal case was closed July 23rd, 2025, when Mr. Kohberger was sentenced. That was the end of the criminal case. The beginning of the case, warrant, yes, Twiz is absolutely correct. He's got one of the 4. Are you speaking of the warrant affidavit or the warrant itself? Hey, Twiz might have 2, because the affidavit of probable cause, that's considered the warrant affidavit. For purposes, if you see a Frank's hearing, a motion for a Frank's, they're going to refer to the warrant affidavit. What the heck is that? That is the affidavit of probable cause. First one filed by Detective Brett Payne, lead detective for the Moscow Police Department. And that's where he asked for the warrant for Mr. Kohberger's arrest. and the warrant was issued same day, December 29th, 2022. An Idaho warrant was issued. Do you remember who issued it? Which judge? Which judge issued that warrant for Mr. Kohberger's arrest? It says any peace officer in the state of Idaho, you are authorized to basically arrest this person and bring him before the court. Now, it was a little bit complicated because Mr. Kohberger didn't happen to be in Idaho at the time. He was across the country, 2,300 miles away in the Commonwealth of Pennsylvania, visiting his family, as many students do over the holiday breaks of Christmas, Hanukkah, and New Year's Day. That's where he was. Okay. Oh my God, my water just went down the wrong pipe. Sorry about that. Twiz has got another correct answer here. Marshall, yes, followed by Blue Devil is confirming that it was Judge Megan E. Marshall who signed off on the warrant. She also had to find probable cause to issue the warrant. She signed two things on the 29th. It was the warrant for Mr. Kohberger's arrest, and it was the order finding probable cause that led to that warrant. Two things signed by Judge Marshall. Who knows the fourth? A lot of people keep forgetting about this one, but you'll see it on the docket. Go to the beginning of the case. There's four things: warrant affidavit, order finding probable cause, warrant for Mr. Kohberger's arrest, and then there was the criminal complaint. Yes, indeed. The criminal complaint was filed by who? Bill Thompson, ring a bell? Latah County prosecutor, lead prosecutor. He filed a criminal complaint based on everything is based on that PCA. That's why I keep saying, without that PCA, you probably wouldn't even know who Mr. Kohberger is and all of the other people that played such important roles in this case in various ways. All right. So Mr. Kohberger is not in Idaho. He is not in Washington State. He's across the country. So what happened a couple of days beforehand is Detective Brett Payne is dealing with the authorities in Pennsylvania, specifically the Pennsylvania State Police, because they can't go knocking down the Kohberger house to arrest Mr. Kohberger. It's not their jurisdiction. They can't go into another state and do that. They needed the Pennsylvania State Police. And who were the two again? This is a very, very important quiz question to know what happened the early morning hours of the 30th of December 2022. It was Pennsylvania troopers Leary and Knoll. Leary, L-E-R-I, Knoll, N-O-L-L. They filed the Pennsylvania affidavit of probable cause that got the magistrate in Pennsylvania to approve of the Pennsylvania nighttime warrant. And it was Leary who actually physically arrested. It wasn't the feds. It wasn't Detective Payne, although Detective Payne was over there in Pennsylvania at the time. He wasn't there at the house. It was the Pennsylvania State Trooper, Leary, who physically took Mr. Kohberger under arrest, put him in the car. They brought him, they did a little pit stop over at the barracks there where Mr. Kohberger had a little interview. I'm wondering if that's what they're asking for, the interview of Mr. Kohberger. One of the things that people have been wanting to see for so long, ever since we knew that Mr. Kohberger was interviewed by who? By Detective Brett Payne. Where? At the Pennsylvania State Barracks, along with a member of the ISP who traveled with him. The two of them interviewed. And it was a video interview. Wouldn't you want to see Mr. Kohberger within the hour after his arrest? Body language. How's he responding? I want to see him. I want to see him within the first few minutes tell Brett Payne, "You look familiar to me." Yeah, Mr. Kohberger said that, according to Detective Brett Payne. And if we can't see it by video for whatever reason, that Pennsylvania State Police, that's where the videotaping happened. It was their barracks in Pennsylvania, where this interview of Mr. Kohberger happened, that the public has never seen. They're talking in this complaint right now that's working its way in Latah County about Pennsylvania law. They want things from Pennsylvania. I'm thinking, so right away my mind runs to, could it be the video of Mr. Kohberger? Hello? That would be amazing. And then I'd like to know what ISP's excuses are. Because also, the ISP detective who was in the room with Payne, he audio taped that interview. All right. Obviously, we want to see the video. No questions asked. But if we can't see the video, I don't know why ISP hasn't dropped that video or that audio tape. It was their officer who taped it. He took out a recorder in his pocket. Hey, I don't care if you can't hear things. Whatever excuses you got, that should have been released to the public a long time ago, as far as I'm concerned. Hey, Carrie Match, it's so good to see you. Twiz, we all do. Glenn, yeah, you want to watch that video, Glenn. You know, where he's talking, Kohberger is telling them, oh, yeah, I did work for all these law enforcement agencies. You know, when our graduate studies, that's what we did. Cloud-based, that's what he was working. I want to hear exactly what was said. You know, when we see body cam, after you've read the report, let's just say, the report from Smith, Officer Smith of the Moscow Police Department, and body cam of Officer Smith from the Moscow Police Department of November 13th, 2022 are two completely different propositions. They're two very different. I want to see the body cam. I want to see the video. I think it's important. So this might be, yes, Amy, boom. This might be what Pennsylvania records they're asking for. All right. So we got so now we have this case highly sealed. I've declared it, in my opinion, again, my opinion only. My opinion doesn't mean anything more than anyone else's. If this isn't one of the most sealed cases in U.S. history, similar case like this, multiple unalivings, very tragic as it may be, unalivings happen every week in the U.S. They're prosecuted every week in the U.S. They're not sealed like this one with a gag order on top of hearings that are not noticed and happen behind closed doors. On top of the pile, as I've called it from day one, the virtual Mount Everest of documents under seal. That's what lends to the secrecy of the case from day one. So now we have Judge Hippler, who denied the media coalition's motion. They actually asked to have the case unsealed, not the gag order. Gag order that was set aside. That merely said that you didn't see what you see in other cases. You didn't see maybe the Moscow Police Department give an interview. How do you think the case is going, Chief Fry? We didn't see any of that. We didn't see the defense or the state of Idaho once in a while put out a presser saying how they believe things are going because of that gag order. But the documents under seal, they're completely different. That's all the evidence. That's what I want to see. The evidence that the state of Idaho says that they had to bring this case that would be at the beyond reasonable doubt evidentiary standard in this capital case, right? They weren't just looking for life in prison. They were looking for the ultimate penalty. That's what I want to see. And that's a lot of the documents that are these, 89, a lot of them are from the in limine filings. I was very excited, December 18th. I think Twiz was in chat when we were talking about it. And I explained, hey, Twiz, are you realizing what's in this treasure trove? He has said right here on this December 18th order, paragraph A, page 1, he's unsealing all stuff, grand jury related materials. What? Motion in limine regarding DNA IgG evidence under seal. AT&T timing advance records. This was everything that was supposed to be unsealed. All right, December 18th. This has to do with the third court order that he put out, October 16th. We are now nearing the end of March, and that October 16th order is far from being resolved as of yet. It's been over 3 months that he entered that court order unsealing. And the state came back with not one, but 2 motions to reconsider. He's already granted 1, right? He put out a court order regarding the second one, and they will not publish it on the court docket. So we do not know what Judge Hippler is now rescinding from that December 18th order. You're very welcome, Glenn. It's what we're here for. We don't forget nothing, right? I got that entire docket in my mind. It's like printed there because of this podcast that we did where we went down the entire docket. All right. So let's see what you guys are saying here. Oh, it's the Warren Commission. Yeah. I mean, this is what it feels like. It's like this is an inquest into the assassination of the president or something. National security. I don't understand it. I don't. Glenn, Smith struck you as being okay. I have to disagree with you. He walked in and out. That back door was supposed to be the point of entry. And it was like, it wasn't all the way open. It was only halfway open. How many times did he go in and out of that back door? Walking over where again, this is the Moscow Police Department's theory in the affidavit of probable cause and everything else. The suspect entered and exited the back door. What's Smith doing walking out of that, in and out of that back door? Over the steps. You know, you talk about contamination, hanging out in the kitchen. No, if you're supposed to be guarding the back to make sure nobody goes in, get outside, put on another coat. You don't hang out in the kitchen, you know, like it's a conference room. Because the concern that I have had, I mean, you look at that body cam footage, including this recent one that just came out that Connor got a hold of. How many people were in and out of that property? Multiple times, back and forth, up and down steps. Now have someone who was a crime scene investigator look at those body cams from the first responders. They're taking the dog out. Murphy might have had evidence on him. What are you doing taking Murphy out? Did you check with ISP first? ISP didn't go in until they got the warrant. Nunez, you see him leave in the middle of the afternoon. He's running back to the Moscow Police Department to write up the proposed warrant that Marshall signed. Then they were able to go in because this was a private residence. They were going to have to go in and take stuff out. So, Glenn, I got to respectfully disagree with you. I think he was a disaster. All of them walking in and out. Once they saw that crime scene, you had 4 victims unalived in the manner that they were, and nobody's hiding anywhere. You know, the bottom closet, they never checked. As Outcast has said many times, you could have had somebody hiding in there. They were like, oh, this door is locked. Oh, okay, no biggie. I'm like, dude, maybe you got somebody in there with an AR who's going to open up the door at any time. Or maybe you got somebody hiding up, hiding upstairs under a bed somewhere. Once you clear the house, get out. Don't keep going in and out, touch. I don't care that they had gloves on, because those blue gloves that they wore, black, whatever they are, they're touching one surface, then they're touching another surface, then they're touching another surface. They got no booties on their feet. You're taking evidence away with you, even if you don't think you are. It's just how biology works, and you're dropping evidence. I want to know how much ISP tested was from the Moscow Police Department. Their fingerprints, there is a lot of tears, whatever, hair that might have fallen. I sure as heck saw the second in command walk across those footsteps in the back that Smith took pictures of in the snow, and that the Idaho State Police took pictures of that night. I'm like, I want to ask them, hey, did you guys take photographs of the Captain Lanier's footprints back there and Smith, or do you think this is the perpetrator? Oh, thank you, Glenn. Smudging Prince Hayden. That's exactly it. Twiz is saying one officer looked like he intentionally touched all over the banister going up to the 3rd floor. What officer is that? Again, this is all alleged. We're just giving our opinions as we see it. we're just giving our opinions as we see it. I don't know why they needed to have multiple people going there. I could see Brian Snyder. I could see Corporal Snyder going around to take photographs as early as possible. Very important that he did that. Of course, there's no caption of a sheet that he took, and he got up in that little room and he got up close and he took photographs. You didn't see the sheath? What? Don't you people hunt up there? You're not familiar with K-bars and sheaths? Not one of them mentioned a sheath. That's why this body cam image, I think that this plaintiff is looking for is so important, because we don't have the equivalent of what that room looked like, not the absolute disaster, the catastrophic injury, not that. I'm talking about the sheath. That's it. We have not seen a picture of the sheath at the crime scene. Not yet. We've seen photographs of it in the lab on the 17th of November, Meridian, hundreds of miles away. We saw ISP's photographs, a few of them, of the sheath on the bed. Second best, third best. The most important stuff is, what did they capture on those body cam images, especially the first one up there, who we believe is Nunez, followed closely by Warner, and down the line. Hey, Leslie and Billy, thank you for joining us. Happy you were able to join us here. Hayden, I'm glad you made it. I'm really happy that you're here. It makes more sense that they already, it didn't seem like there was any fear, Twiz. I mean, they're met at the door by somebody. Not throwing any shade at anyone at all. I just wonder how the New York Police Department, or some other town, might have handled things if you've got 4 people who were unalived in the way that it looked like these. Of course, there were some people that were saying, including on this last body cam imagery that Connor got, suggesting it could have been a pew-pew. It could have been another weapon that caused some of this damage. But you see a guy standing at the door with a weapon in his hand. I mean, I know it was small. It wasn't a K-bar, but still. And you go in, you don't know if you're going to get jumped the minute you walk up those steps, if somebody's going to come behind you, hiding in one of those little rooms downstairs. You don't know. You don't know if there was 1,001 places that people could have hidden in that house. 3-story house, all types of, turns and this and that. It just seemed, I understand, and I appreciate, people have put out comments, a lot of comments, that it didn't seem like a sense of urgency. It didn't seem, and then I say to myself, well, Nunez was very young. I think he was 22, first year rookie. Maybe he didn't know. They certainly didn't have this type of an event happen in Moscow before. It had been 2015 since the last unaliving. I mean, it wasn't like they were used to giving out parking tickets, noise complaints, maybe a DUI once in a while. They didn't experience like this. So maybe they just didn't know. Okay. And Hunter didn't know they were in the 911 call. GTFO. Yes. Hello, Mel. I'm glad you're here. Thank you. Thank you so much. Put them on the ground. What can we do? Oh, I know. Carrie, I'm having a hard time. I looked at that. I'm trying to think who published it. Somebody published that Connor's video, and it came up on my feed. And then I don't even think I made it to where they were removing the students, because it was like, oh God, this is nighttime. They're still walking in and out of that house. Like it's Grand Central Station. I had to turn it off, to be honest with you. Disrespectful. And Zana was cremated. Yeah. LA would be worse than Moscow, according to Carrie. It would be worse. It would be a worse situation. So anyway, getting back to the issue of documents under seal. It has been almost 9 months since, Mr. Kohberger stood up in open court and pled guilty, which got the trial canceled and everything else canceled. That was it. And nobody else has ever been arrested. There hasn't even been a hint from the Moscow Police Department of the state of Idaho of a co-conspirator, an alternative perpetrator, an accessory before or after the fact, like a getaway driver or someone that feeds information before. No whispers, not even, okay, much less no one has been arrested in the 3.5 years since these horrible tragedies. Why is this case under seal? No appeal. Why is this case under seal? No one can, maybe people don't have interest in seeing the documents. I do. I think a lot of people that follow my podcast do, and a lot of people who follow this channel do. They want to see the documents that they should have seen, quite frankly, when the case was ongoing. If it wasn't, as somebody had said here in chat, acting as though this was a matter of national security that really needed to be under seal. So, thus far, there's been a few documents from May, June, July, and August that have been unsealed. One document from March, the one that got unsealed in February, having to do with text messages. And that's only one of the briefings in that one motion in limine. There were a ton of motions in limine. One of them had to do with should text messages be allowed in the forthcoming trial, because there was still a trial that was supposed to happen in August at the time that the in limine briefings were filed, or not. Motion, we've said, motion's a request or an application for a court order. In limine means before trial. A lot of those motions in limine dealt with what evidence should be admissible, what evidence should not be admissible. He released one document. It was a response by the defense to the plaintiff's motion in limine regarding text messages. So there's another document with things under seal just in this one briefing. The plaintiff's motion regarding messages that the defense responded to, and that's what you saw a few weeks back. The stuff under seal to the response. What about the reply? Where's the motion? Where's the reply with the stuff under seal? And that's just one in limine filing. So everything has pretty much come to a standstill. I don't know what it is about this October 16th court order for January, February, and March 1985, but this is where this roadblock got hit. 3 months ago plus, he puts out this court order to release these documents. Nobody, okay, so the state comes back, one motion for reconsideration, a second motion for reconsideration. He puts out the court order, and he won't publish it on the docket. So it's all of this just playing hide the ball upon hide the ball. And in the meantime, more stuff's getting sealed. I had thought maybe by 2027, at the rate that he was going, he came out with a court order every month. And within that month, the documents were unsealed for whatever period it was. I thought, okay, it'll take until 2027 to unseal this case. We're lucky if it's going to get unsealed by 2030. At this rate, haven't even gotten into 2024 yet. And that's where the aforementioned Franks hearing with all of the evidence under seal in support of the Franks motion got denied, and all the motions to suppress got denied. That's the end of 2024. That's when we're getting further into evidence. So that's where we are. What's this, Carrie? And the coroner made a bizarre comment about taking a souvenir. What's this? And I saw her out there. It's what? It's like 9:15 at night, 9:30. Yet she clocked the time of passing noon. She wasn't in the house at noon. Nobody was in the house at noon, as far as we know from the Moscow Police Department. Nunez steps foot on the parking lot in front of the house a couple minutes after 12. It's not for several more minutes that he gets upstairs and he's able to see the absolute tragedy that was in Xana's room, and then upstairs in Madison's room. Where's she getting 12 noon is the time of passing? She wasn't in the house then, at least as far as I know. I don't know anything about that. I'm not sure what the souvenir is, Carrie. So anyway, Michigan bodies until, why not? People just blow me away at how fast they can type. Me too, Melba. I'm very, very, very surprised. HVAC truck first, way before what? The HVAC truck, Amy. We're talking November 13th, right? How about the HVAC truck that pulled up to the crime scene December 30th, the day of Mr. Kohberger's arrest? They were going to go in there and do deep cleaning. It's like, whoa. If Ann Taylor didn't jump in right away and file a motion with Judge Marshall to stop them, they would have deep-vacked that entire house, right? And let's not even touch the Chief Fry Moving and Storage Company that happened in the middle part of the month when they're going in there and they're taking things out of the crime scene. I picture the Far Side cartoon with the skeleton. Oh, they were perfectly broken. Yes, that would be, I would be part of that. The Far Side cartoon where our skeletons are reading the documents. Right. It'll probably come out 2075 or something like that at this rate. So that's where we are right now. We have all of these lawsuits. Things are, the only one where things aren't happening is Idaho versus Kohberger, the process of unsealing. That seems to be, I can't even say it's going at a snail's pace. It went at a snail's pace about 3 months ago. At this point, it's just stopped. Bottom line, it has just stopped. So anyway, we got the other cases. A lot happening in Goncalves versus WSU. A lot happening in this new lawsuit regarding EWU. I am wanting to see if any content creators or people that filed documents, public records request, and they keep saying they didn't respond. Are they going to intervene? Christy Nevada's intervener. She said that she filed a public records request and she was disappointed with how things went because she felt they didn't follow the law. You might see some people who did that. That's the time to do it. Intervene, come in. This is an issue right before the judge. Judge is being asked, did the Moscow Police Department and the city of Moscow, did they violate the Idaho Public Records Act with these rulings, with these decisions, not rulings, with these decisions? All right. A sloth going in revenge. Release keeps trying to hit back. Well, so definitely subscribe to the channel because we're going to be putting out a lot of content. There's a lot of stuff going on right now. And I'm going to be continuing to do what I can to hopefully other people will also speak out and say this May 18th hearing is important and it should be live streamed because as the public, we're all invested in this. There were who knows how many hundreds of thousands of dollars were spent on federal employees who worked this case. You getting ready to pay your taxes? Did you pay taxes in 2022, 3, 4, 5? You helped pay for this investigation. Okay, so you can pay the bill, but you can't see the proof of the work. I don't get it. But anyway, okay, the souvenir, the coroner made a joke about disposable boot. Oh, okay. To retire before the slot going. All right, guys, any final questions, any final thoughts before we head on out? All right, guys, stay tuned to the channel. Please subscribe, please like, please share. And we'll definitely be doing more lives because there's a lot going on in these cases, okay? I want to thank everybody for being here tonight. Thank you to those of you that participated in the conversation in chat. And we will see you soon. Bye now.